over here. And section 6.2 is the use table. So the residential side of things, there we updated by adding terminology for multifamily buildings, multifamily residential use, and for single family residential use. So we added some terminology there to be crystal clear of what you were intending to regulate. There is distinctions in the law between what you may regulate as what a structure looks like. Like a multifamily building is more of a structural limitation, how many dwelling units can be attached, versus the multifamily residential use within that building. And so your ordinance was, I believe, attempting to come at it to regulate both kind of things, but we want to be crystal clear that moving forward by listing both types, the structural limitations and the use limitations in this table. And then in the ordinance, the next section, which is section 5 here in the ordinance proposed, are the commercial use changes in the permitted use table, where we added the use terms transient dwelling, lodging, and whole house short-term rental. And I'm going to go through this again a little bit more detail, but we tackled obviously updating the permitted use table. Then the summary I'm going over in item 6, we clarified that currently the intent is to not allow the occupancy of a RV or a temporary structure to be someplace where someone purports to live, either temporary or not temporary. So we added or proposed changes to the sections that deal with customary accessory outbuildings, as well as recreational vehicles, to be crystal clear that they are not to be used for residential or lodging use of any kind. And again, these are concepts, these are policy suggestions that are being made at this point in time, but I believe from the working group's perspective, this was sort of the intent all along, and we were just crystallizing that intent. At item 7, we sort of updated and made some slight tweaks to your tourist home section, which I'll talk about a little bit later. But in the ordinance, that's item number 9, which starts on bottom of page 4 and goes over to page 5. And we'll talk about that a little bit more detail here in a second. All right, item 8 of the summary is the whole house short-term rental. You will find that starting at the bottom of page 5 of the ordinance. It's a new section proposed 6.5.18, whole house short-term rental. I'm going to walk through some of the concepts of restrictions associated with whole house short-term renting. As you know, that term deals with the use of an entire dwelling for renting out to someone paying to use it, to occupy it for a period of time, not less than 7 days, but 7 days up to the point in time where it no longer is temporary. Temporary is anything less than 30 days. So that's sort of the sweet spot for that term. By location, the recommendation of the group, and you can see this in the permitted use table on the previous page, actually it's on page 4, is to not allow this use in R1, to allow this use limited in R2, to allow this use without the limitations in R3, and in your commercial zones of B1, B2, and B3, with coming back on a limited use in your district B4. Now, in terms of limitations that are proposed in R2, one of the big concepts is how often you can use the property for whole house short-term rent. The working group believed there should be a distinction between someone who intends to use that property primarily as that use versus someone who is not using it primarily for that use. And that is, at least was viewed by the working group as a concept of time. So time was, are you using it more than half a year, or are you not using it more than for half a year? If you're using it for less than a half a year, it's more of an accessory use of property. I'm assuming everybody understands accessory is more incidental than a primary use of property. So in the R2 districts and B4, the recommendation is that whole house short-term renting should only be an accessory use of property. So if anybody wanted to use it in that district, they would be limited to a certain number of weeks. And you'll see that on page 7 of the proposed exhibit ordinance is in the conditions on page 7. You'll see in item paragraph 2 a maximum number of weeks of 25, which is less than half of the year. So that is one way to distinguish the limitation in R2 and B4 for whole house short-term renting. Some of the other restrictions on whole house short-term renting is, regardless of where it is, there is an occupancy limit based on the number of bedrooms you have. And that is proposed there in page 7 as E1. And this is very typical to see around the country of local governments regulating short-term rentals to have a limitation. So everybody's doesn't feel like someone's sleeping on the kitchen floor and spread out all over the place, but based on bedrooms. And the working group is very much wanting to protect the watershed and was worried about septic and overuse. And so you'll see that the number of bedrooms may be tied to what septic permit you have. And you've got to show proof of that. There's a formula there that basically for each legitimate bedroom you have, you can have up to 2 persons per bedroom plus 2 additional persons just in case there's a loft or some other place where someone might stay. So this is a very typical standard of 2 persons per bedroom plus 2. It's an occupancy limit for short-term rentals. Another concept of particular restriction for short-term rentals is the fact you have to have a contact, an operator, if you will, someone that is there, that any complaints, people can be reached to deal with any issues that might occur on the property. So you'll see that on page 7 again in E3, a display of contact information for operators. And then if you turn to number 8, you'll see a whole section G on duties of the operator to respond to complaints. Another big concept that for restriction of short-term renting that the group dealt with was the police power concerns that exist regardless of whether it's a commercial use or residential use. You're always going to have parking concerns, so that people, regardless of use, are not parking in the street, whether it's a restaurant or in this case, a short-term rental. So there are standards in here for parking. One limitation is proposal to limit the number of cars on a lot to 4, so that you don't have people parking, in yards and all over the place associated with a short-term rental. But the working group dealt with parking issues, pulled in the town's ordinance on trash and the noise ordinance, so that there is a correlation between that use and those general police power concerns that exist in most communities. One other issue the group dealt with is the issue of vesting. Grandfather, those properties that are currently legally using their property for whatever the use is in North Carolina, our courts recognize the concept of vested rights. And so this ordinance doesn't run away from that. It acknowledges that folks may have some vested rights. One of the salient features of this proposal is that everybody, if this ordinance is adopted, everybody has to come in and get a zoning certificate, whether you're starting anew or you have a current existing use of property that would be legal. Everybody's got to come in and get a zoning certificate. And if you believe you're vested, the proposal here is that you need to come in, get a zoning certificate. The ordinance directs folks to do so within 120 days and prove your grandfathered status. Yes, ma'am.
Just to clarify, would this apply to properties in R1? Or
Yep.
is it just
Oh, it would apply to all districts.
all districts?
And so what I just wanted to point out that this is acknowledging vesting. This is really not a forum to get into the weeds about that, but to understand that everybody still needs to come in and get a zoning certificate. Some people may claim vesting, and you just got to produce the information to support that. And let's see. And then we have proposals to tighten up and modernize your non-conforming vesting section of your ordinance, which is your section 7 of your code, deals with non-conformities. And so you'll see at the very end of the proposed ordinance at the bottom of page 8 and page 9, new proposed additions to your non-conforming section. All right, so that was a quick run through. So let me just summarize some things here. And I didn't touch on tourist homes, by the way. Let me touch on that first. If you turn to page 4, the permitted use table, if you look at the top, the proposed permitted use table shows a continuation of not allowing tourist homes in R1. Right now, if you opened your ordinance book, tourist homes are allowed pursuant to a special use permit in R2. They're not allowed in R1. So this sort of honors that historical treatment of tourist homes. A difference, though, is rather than having to go get a special use permit in R2, the tourist homes are limited to being accessory uses of property. If you remember, accessory uses were tied to how long you can do it. And if you look on page 5, you see the sort of updated recommendations for tourist homes that in the R2 and the B4 districts, just like whole house short-term renting, the recommendation is to allow them as accessory uses of property, which are, again, in this case, tied to the number of days. And if you pick up on the fact that whole house short-term renting is tied to the number of weeks, that's because the definition of whole house is tied to weeks, not days. Tourist homes is not like that, but we have an accessory limit on the number of days being proposed for the R2 and B4 districts. But to eliminate having to go get a special use permit, I advised the board that a special use permit is a scenario for a fight. It is an evidentiary process that a lot of people don't understand, and oftentimes it leads to issues that are unnecessary if you appropriately regulate it to begin with. So the effort here was to appropriately regulate it to begin with to avoid having to do the special use permit hearing, which I believe your Board of Adjustment would be very thankful that we attempted to do that. So the tourist home limitations, again, are adding in the accessory component. We clarified what the working group believed was the requirement already, that the tourist home be occupied by a resident. And we tied back in the parking standards. And we kept a number of the things as is that's currently in your ordinance. So in summary, the whole house short-term renting is a term that is regulated by time, by a minimum number of days, 7 up to 29. It distinguishes that use from transit dwelling use, which is a daily use of a dwelling. And if you'll see in the table for that, that use is only allowed in your commercial districts. As on page 4, you'll see the P's there for your commercial districts, B1, B2, and B3. Tourist home, we eliminate the special use permit requirement, but we were regulating that very much similar to the whole house rental approach. And we just updated your tables, put more clarifications of what the difference between a residential use is versus something that's not residential use. And like Jay said, we spent 2 months looking at a lot of different local government codes. We looked at town of Lake Lure, which I was involved in regulating. And there's Lake Lure as it is. It's not Lake Lure. But Lake Lure had a long process of regulating short-term rentals. And anyway, I was part of that group, and we pulled a lot from Lake Lure. So this was an effort to come up with concepts so we could start the conversation. So I will stop at that moment and ask if anybody has any other questions. Yes.
Just to kind of, just to ask you a question, anything that goes with all these conditions and stuff, does that not totally violate North Carolina State Rule signed in 2019 that says no government body can mandate what y'all are asking to mandate?
I'm not sure I understand which law that is. Having
It's 482, I believe, but it specifically states that no government can require any short-term rental to register or to comply. I'm just asking because it completely will go against that rule, which will be overturned. Just like Lake Lure, didn't y'all have some legal challenges there?
that is what ended up leading to changes to that ordinance. It did not do away with that ordinance, and I was the one suing the town of Lake Lure. So anyway, it got better. Let's put it that way. So the case you're talking about, or the issue you're talking about, is one the city of Wilmington has been dealing with. I'm very familiar with that case. I'm familiar with the statute it refers to. This ordinance is not that. So there is nothing, in fact, there's a clear distinction between having to get a development approval and registration. And I could just tell you, because I can sit here and lecture on the topic for probably 30 minutes. We looked at that, and this proposal is not the city of Wilmington proposal.
I guess I'm not just trying to put it into a group of Wilmington, like it was a specific law signed in July 1st, 2019 that specifically states, Governor Cooper signed it, that what these amendments that are asking that we do are a complete violation of state law.
So so I was part of those legislative changes. Okay, there was a 160D committee, and although I wasn't a direct member, I was involved with the North Carolina Home Builders Association. So I was in most of the rooms when this was being worked on. Legislation 2019, I personally wrote part 1 of the bill where a lot of this stuff is. And I can just tell you that at the end of the day, Wilmington is a very, very narrow issue. There was an effort to write in a complete prohibition or preemption of local government's ability to regulate short-term rental. And that did not happen. There, in fact, the efforts of those advocates tried to attach it to the budget, in the most recent budget cycle. And Governor Cooper negotiated that they be taken out. So they were not adopted an express preemption. So I could just tell you that the city of Wilmington issue was looked at, and we did things to avoid the problems that they're having. And there is not a ban on local governments from regulating short-term rentals. It is always comes down to a question of reasonableness, grounded in what your land use plan would say is the vision of your community, and you try to strike a fair balance. You should ban them. Shouldn't ban anything that's not a nuisance per se. So this proposal right here, in my estimation, is perfectly legal and reasonable. And I think Jay would agree that I was brought in because sometimes we do butt heads. And I'm the one screaming on the other side of the fence for things to be different. And so that's where you try to find the middle ground. And so I was asked to come in and look at it from a different perspective. So I'm very comfortable with the fact that this town will have lawful authority to adopt what the working group is as conceptualized.
So I have a question more on a conceptual level. Under this, what I refer to as a straw man, is the understanding correct that the existing short-term rentals that have been used for that purpose for the last several years would be vested and would be able to go about their business as they have?
As a general rule of thumb, that is correct.
Okay. And
The devil is in the detail.
So would they have to comply with the other elements in here, with respect to parking and sanitary sewer and limitation on occupants?
Not necessarily the limitation on occupants. Again, the devil is going to be in the details.
Okay.
So what is grandfathered is your historical use of property. Not everybody uses their house the same.
So if an example would help me, if someone somewhere in the town of Highlands, let's say in an R1, has been renting a house, whole house with 4 bedrooms, and they advertise as Sleep 16, and that's what they've been doing, what would change in that situation if we adopted this as?
I will address the hypothetical. Okay. It is not a great forum to talk about specific examples until faced with specific examples. First off, I'm not the zoning enforcement officer. So
I'm just trying to understand.
But in terms of because this is a perspective ordinance, right? Moving forward, it acknowledges there may be vesting and that we're going to honor in this, but this is a move forward. So in the hypothetical you get was, let's just say someone's been using their property for renting out their whole house to up to 16 people, let's just say for 5 years prior to the adoption of this. They've been doing that continuously, and they've been doing it, let's just say they've been doing it for more than half the year. Well, if they came in and showed proof of all that, this ordinance wouldn't take that away. It's not intended to. It would, if that is proven, then they would be allowed that historical use. Now, what would potentially be affected would be the trash, the things at the end, the general police power concerns about parking. It doesn't give you a right to just park willy-nilly anywhere you want. Trash doesn't give you the right just to ignore your trash ordinances. Doesn't give you a right to violate your noise ordinances. Those things will all matter.
And those already pre-exist.
They all pre-exist,
So
and those things continue
So
to matter.
for the neighbors of that house, nothing has changed.
In that respect, as long as trash and noise and parking is all fine, nothing changes them from being able to use it for up to 16 people for more than half a year.
I'm sorry, go ahead.
I'll just say if there were septic issues, would that change?
If there's a septic problem, then that is a overarching law that will be a problem. So your hypothetical would have to be no septic problems. Because this is a watershed area, and that's gonna trump everybody else.
So if they had septic problems before we adopted this, we've already got laws to deal with that.
You got laws to
So
deal
there's
with
no-
that, but
no
that might
change.
affect the number of bedrooms, that might affect if there were septic.
The one thing that I thought was different, sorry, please tell me where it was, if we covered it, that somebody had to be responsible for the property 24/7, like, where was that? Sorry.
There's some two places in that.
Yeah.
That is on page 7, item E3,
Yeah,
as well as G on page 8.
okay, so that would actually, as far as I know, that would be something different, would it not, if we adopted this?
I didn't say, that was not one of the examples I said would apply retroactive.
Gotcha.
Now, I can tell you that as a neighbor and a smart management, you, I think probably a lot of people already do have that. But again, this is a perspective ordinance, and I'd rather not, Jake can chime in, I'd rather not get to too many hypotheticals.
And
But
understand, that my hypothetical is because, to me, this is very detailed, we could pass it, or someone would pass it tonight. I thought this was a conceptual conversation.
It is a
And
conceptual
apparently
conversation.
the conceptual conversation happened earlier, and then these are the details that are how you build. I'm just trying to understand it through asking some of these questions.
Oh, well, it may appear, well, let's put it this way, that when I said conceptual, it is meant to say, you could throw this out tomorrow or tonight if you don't like any of it as a planning board. But these are concepts. They're very detailed concepts, sure. The working group spent a lot of time at it. But there's nothing binding here. These are just,
Understand. But the big picture is, I won't use the word conceptual because we get different meanings, but the thrust here is we would allow anyone who's been doing this for some period of time to continue as they always have been with no new regulation or restrictions, but the new properties that want to be put into this kind of use would have to comply with all of that.
I think that's a fair statement.
So a question to I don't know who the working group was, but
Amy, Brian,
Okay. Does that concept solve the problem that we set out to solve? I'm not sure how we define the problem, but I'm guessing a lot of people would say that doesn't really solve the problem they came to solve.
The problem is that you have to, whatever we have to do, has to be done with an eye on the legality of the law.
Right.
There are things that we feel like that we have put in there, whether it be more enforcement of parking and things, because part of it just comes down to enforcement. You say the septic thing has already been there, the parking's already been there, but we have not actually done anything about it. So those are things that would actually be done in the future. But the other thing to remember is it's two separate things here. One of them is this prospective going forward from now. And then the other thing is who and how and are they vested?
Yes.
And that's a separate problem and a separate question.
If you do not address the future, then whatever is going on here may just be exacerbated. So you gotta address updating your ordinance, regardless of whether or not you feel like what's in the rearview mirror is a big problem or not. But as Nikki said, there's a lot of detail in historical use of property.
Yeah, I might add one thing. I know lawyers are quite often accused of trying to get to court. Most lawyers I work with aren't that way. They try to avoid going to court if they can. And what Amy just brought up it involves that issue very much. This document that I want you to read real closely and think about and talk later on basically says that people who have vested rights, as that would be understood in court, are going to be asked to come forward, prove how they are vested in a certificate application process that will pretty much capture them into the fold of vested uses. And those, when they are in that category, then they would be able to continue their use in the future. If they don't try to become a part of that category under the new UDO, they could still go to court. What we're trying to do is to avoid that by saying, would you please just try to apply for a certificate so we know who you are and you come into compliance with some of these things that we think is fair enough for everybody. So we're trying to avoid that, but it could be that someone could say, well, I'm going to be the maverick here. I'm not going to get that certificate. I'm just going to go to court on my vested issue, which is not what we want to do. We want to try to get everybody involved in this as much as we can, understand what their rights are. And once you have this vested section, the rest of the uses that are there are pretty much written in stone as R1. No further person who didn't have vested use would be able to go forward in the future and do a short-term rental unless it's strictly complied somehow with this ordinance.
And that includes once the property changes hands too. So if somebody was
Right.
vested
Yeah,
in, so once a new owner comes in, that's a whole
Right.
process.
Yeah, and I think people have a misconception about limitations on local government authority. You lived in a subdivision and you had a set of covenants. And there's an amendment process that you could go through with your neighbors and amend your covenants. It's easier to apply those covenants retroactively to say to your neighbor, we've changed the covenants, now you have to change your behavior because we've changed the covenants. And because that community is not subject to the Constitution of North Carolina as interpreted by the courts in the realm of vesting. It is a constitutionally vesting grandfathering is a constitutionally protected concept. So there are limitations on which you can just go back and retroactively disturb vested rights. So to the main, this is looking forward with the idea that people will still have to come in and prove that they're vested. Yes.
Just clarification, the short-term rental is defined according to this 7 to 30 days or 29 days. So if somebody comes in and they're vested and they've been renting their property for 3 or 4 days, can they continue to rent their property for 3 or 4 days, or are they required to rent it for 7 days?
So yeah, there's a lot of detail that goes into that. I will tell you this. If someone said, aha, there's a vesting concept, let me just run off now and do something. Then, and your proof is, look at what we've just done. I think that will have a certain flavor to it that's different than someone who's been doing it for 5 years and they've been doing it daily or whatever you just got through saying, less than a week. And that's how they've been historically using their property. And they can show that. Then that usage, that historical usage is going to be entitled to protections. Yes.
So it's House Bill 829 is what I was talking about. And it specifically states, in no event may a local government do any of the following: adopt or enforce any ordinance that requires any owner may property obtain any permit or permission from the local government. So basically that's what I was.
Yes, House Bill 829.
829,
So if you look, did it get enacted into law?
May 5, 2021. Well, actually, it was July 1st, 2019, or the 20. That was that amendment. which
July
was-
when?
It was May sorry, I don't know why, I just clicked off the page. It's May 5th, 2021,
So North Carolina House Bill.
829. Just updates the existing. That was all the clarification. I just needed clarification on that.
So this is technical corrections, 160D, House Bill 829. Is that the title of it?
Well, I mean, you can go to either one. You have short, it could be chapters 160D, technical corrections. I had the whole thing. I mean,
No, so
The
in
section
no
would be-
event, adopt or enforce any ordinance that require any owner or manager of rental property to obtain any permit or permission, and then it strikes
Strikes
through
through
under
Article
Article 11. And so let's see what it, second reading, pass the House. So
Let's have
this,
a violation within 4 violations.
I
within
understand.
12 months.
So this is going to be the one that was attached to the budget. And it was not enacted into law.
Okay.
Um,
It
Very-
says this act becomes effective October 1st,
Oh,
2021.
I know that's what it says, but it has to be adopted and signed into law, and it never did get adopted and signed into law. So this was one of the ones that were attempted to be passed, ultimately tied to the budget and got negotiated out. So. All right.
So another broad question. What, anything like this comes with unintended consequences down the road. Have we thought through what those are? What is it in 5 years? We'll look back and say, we didn't think it would lead to X. Have we identified any of those things? I can't sit here and say what they are, but just like rent controls, they're unintended consequences.
Yeah, we had a crystal ball. We looked into it.
So I think.
Well, I mean,
there
there's some
was-
things you really can.
We really did try to think through a lot of different things that might come up, might crop up. Have we got it covered? Is it something that might happen? We think that we have, but who knows? Who could have predicted that social media, Airbnb, and COVID would all converge in this one spot that changed everything for this type of residential use? But that's what happened. I mean, that was the perfect storm.
Right. I just don't, the thing that I guess we need to all think about a little bit in the next few weeks. Do you end up with having these vested properties become more valuable because there are no new properties coming online in R1, and therefore, when they go to sell, they're more about, they'll be stuck in that category. I don't know. I'm just.
But in that case, right, what you just said, like, it would change the ownership. So it's not like you could sell, you see what I'm saying? Like, yeah, you're getting to do it, but you're next the person. you
No,
sell
it,
to.
No,
no,
it
it's
goes-
it goes with the
Oh, it
land.
does do that.
It goes with the
Yes.
land.
Yeah, you're
Ah,
creating a
So
new
you are
class.
creating.
Yes,
creating a
and
new
then
class
we'll-
of property.
the new owner could do it.
And another thing that we tried to predict what might happen is workforce housing. Its availability in Highlands and the whole house usage and the effect it has on the people who come here to work.
Right.
They have to drive long distances to get here to work.
See, I think that's a straw man though, because you're assuming that people will rent their property long term. Well, to me, that's just an argument.
Yeah.
But I think, well, I'm speaking for the working group, but if you go back and drill down to what is R1 supposed to be? What is R2? supposed to be? What is R3 supposed to be? So your ordinance is set up very like many traditional ordinances are set up. It's the Euclidean approach based on the Village of Euclid case from the 1920s. It's, that ordinance was set up where you had districts to exclude things that right? Residential separated from commercial, commercial separated from residential. And then you had generally grades of more restrictive to least restrictive. All right, so your ordinance is set up like that. And typically it's done that way because you say, well, R1 needs to be more purist about, families, and you have your neighbor going to the, being a member of Civitan, or what is it that you were saying? The
Rotary Club.
Rotary Club, right? And that's your neighbor, or they go play soccer, their kids play soccer. It's that, preserving that concept of R1 and the integrity of your neighborhoods, right? So R2 is a little bit different. More things are allowed. R3, more things allowed. Multifamily. Commercial's different. So it's the idea of, well, how do we, in light of the need to modernize and update your ordinance, how do we stick with protecting the intent of those districts? So the working group ended up with this. So if you don't do this, then whatever is going on today, more than likely will continue to go on. And more of it, more of it, more of it.
Well, I don't know that we have only two choices here. Do this or don't do this. I mean, this is a conceptual conversation.
Correct.
A workshop. I hope that it's not a binary choice.
Oh, goodness, no.
Right.
Oh,
So,
goodness, no.
but let's make
And,
sure
and
we
all the
understand we got
unintended
some latitude.
consequences are supposed to be,
Yeah.
you try to be vetted through a public debate and planning board discussion, and, looking at all that.
That's your
I
job.
think, yeah, well, two consequences that, you can kind of see coming on the horizon. This is, town still wants to annex places into the city limits, does it not? For the tax base. Just in the future, they don't want to bring in anybody else. They don't want to bring anybody else in
I don't think
sewer.
that's a concept that we're saying we want to.
Okay.
I'm not saying that.
But
you're
I guess my
not,
point
but-
would be
but
like,
We are not proactively trying to do that.
if there was a place that wanted to do it, that would be less desirable to do, because once you did that, now you fall under, well, if I was making money renting my house, I can't do that anymore. Or I would have to do these things. That could be one in the future. You were just asking. It's another thing, and I've noticed this from other places that do a lot of short-term rentals, is that, and I don't even know if this is possible, but if you had a certain house, you would not only want to know that there was somebody on call and somebody you get to, but possibly within the city limits, a minimum on a rental. Because what happens is, with so many of these places, is you get, people who own these properties, and that income becomes income. And when it's not as much, it's, well, let's lower the rates, let's lower the rates, let's lower the rates. And effectively what you get is a completely different type of, clientele, customer, guest that comes to your town. I don't think we're in the place that you would be if it were, say a beach town, or, a big single city or something like that. But it does happen, and it's happened to a lot of communities that you've seen that are the size of ours. So that would be something that I would want to look at too, like down the road. If consequences for some of this stuff. But I certainly don't see a problem with this type of, hey, you've got to have somebody you can call in this house. We got to have somebody we can contact if there's a problem. We've got to have somebody that we can get to if you've had these violations, and the enforcement of it, getting, if you want to be serious about it, yeah, you got to get after people who are consistently, challenging this thing.
Okay, we've been hearing this presentation and discussing for an hour, over an hour now. I think it's at a situation where the planning board will need to review the document and do your analysis and make your recommendations. Now, how long that will take you, remains to be seen, but, we've started the process at this point. So I think it's time to bring this to a close for tonight, and then this conversation and this review will continue as we go forward.
If we start part of it,
Yes. So,
Brad can keep going.
right. And with that, we can adjourn. Want to thank our attorney for doing this presentation tonight.
No, this is theirs.
And I appreciate the work group for all the work you've done. And we will, I'll entertain a motion for adjournment for the town board meeting, and then
We'll
Mr.
continue
Armstrong,
on.
you
We'll
can
continue on
continue.
with
Okay, do I have, all in favor, please signify by saying aye. Thank you. We are adjourned, but you're still in session.
No, they
No,
lost
we don't
their,
need to
they lost their
consider it.
sentence. Jesus Christ.